Reddit lawyers, which case made you feel like Sherlock Holmes after you won? Story 1. Not me, but my brother managed to force a major bank into the discovery process in a lawsuit, which is totally unheard of due to arbitration laws. The bank's agents had ripped off a wealthy old lady of all her money, and she didn't know anything until her lights were cut off. After fighting and delaying discovery until the very last minute, the bank dumped over 200 boxes of documents on my brother the Friday before the Monday discovery hearing. He had 72 hours to go through tens of thousands of pages of documents. He rented himself a hotel for the weekend so he'd have no disturbances, had a friend bring a dolly and hand-truck the boxes to the hotel room, and got to work. In one of the boxes was an email between two vice presidents at the bank, discussing how there would never be a discovery process, so there was no need to destroy documents, that is, evidence, and also saying that they weren't worried about the little old lady's lawsuit, since the bank had frozen her accounts on some trumped-up fraud allegation, so she wouldn't be able to pay her lawyer and he, my brother, would surely quit. The lady had Alzheimer's at a fairly advanced stage by this time, so the email discussed how she would likely die before her accounts would be unfrozen once the fraud was proven to be false. These chuckleheads openly discussed several illegal acts and emails to each other, and then failed to destroy the paperwork proving they had actually undertaken those acts, which, legally, they could have destroyed at the time, but they were so arrogant they thought they didn't have to. When my brother entered that into evidence Monday morning, they immediately motioned for a recess and offered to settle for, an undisclosed sum. He also won his client $10 million in a separate part of the lawsuit. One agent is currently serving a long sentence in the same federal prison as Bernie Madoff. Sadly, the lady did in fact die before the case settled, so the money went to her son and to a large charitable trust that then elected my brother as the main trustee. So he gets to disburse the money he won in the settlement and see a lot of people benefit from his work. Pretty sweet. Edited to add, I feel obliged to spread the anti-arbitration gospel of my brother. If it weren't for a fluke technicality that led to the boilerplate arbitration clause being thrown out, there would have been no discovery and no justice for this lady. Under arbitration, the banks and large companies always win. Always, always, always. Don't sign arbitration agreements, cross the clauses out and initial the changes. If they won't accept it, go to another bank or whatever. Don't give up your right to sue, please. Story 2. The ghost. Okay, so, in the first place, it's always nice to get a client from a business card you left at a diner. It means people pick those things up. However, when leaving business cards at diners in certain areas of town, I should expect some issues. This call came through on a dreary December day as I was sipping coffee and watching the snowfall. The caller ID read that it was the local hospital, and as I picked up, I spoke to a rather frantic young man who informed me he was being held against his will and he needed an attorney to help him. When I asked where he was, he simply said, the 5th floor. While this may sound innocuous, every hospital has a 5th floor, where Napoleon roams the halls freely, and the residents speak to their imaginary friends, who may, or may not, have been an influencing factor in why they decided that clothing was a way for the government to track them, and therefore the only solution was to create poop pants, to throw off the monitoring ability of the Central Intelligence Agency. Long story short on this portion, within an hour of the call, a friend had dropped off my fee, and I was en route to the 5th floor to meet with my new client. I assumed it would be an involuntary committal defense, and after speaking with my client, I gauged that, while the man was most definitely in need of mental care, he was not a danger to himself or others, and was unlikely to be one. He had, in my opinion, been forced to agree to being committed by his probation officer, and frankly, I wasn't going to let that stand. I got the name of some contacts from his treatment plan, who were willing to vouch that he had, until recently, been compliant with his medications, and contacted his social worker who was able to confirm that, yes, since he had ceased taking the medication due to an inability to afford the medications, the county would assist him with it. A slam dunk, I would simply swing my big lawyer ego around the mental ward and get him released, then appear in the court to defend against the involuntary committal. Within 24 hours of being committed, my client was back at home. A hearing was set a couple weeks in the future, and I did daily checks to be certain he was compliant with his medication leading up to the hearing, until the one day I didn't. A call from the local police was my tip-off. An older officer, one I was familiar with, called to advise they had responded to a disturbance at my client's home. He apparently had been screaming in an empty room, loud enough that the neighbors were concerned, and called the police. The police officer, a friendly sort, gauged the situation and decided my client wasn't a threat, but asked what the situation was. "The ghost," my client had responded. "The ghost won't get out, and it won't leave me alone." "Well," said the officer, "I can tell it to leave." So he did. He told the ghost to leave. And then, apparently for fun and giggles, told him that it was a civil matter if the ghost refused to leave, and therefore an attorney would need to be contacted. At which point, my client dropped my name, which resulted in the cop giving me a heads up. So I call my client, Dot, who is inconsolable at the concept of sharing his home with the ghost. Keep in mind, I've been to this guy's house. This is the first I've heard of a ghost. But there is a competency hearing on the horizon, and this will not play well in front of the judge. The cop said it's a civil matter. My client repeated about the 18th time after I told him I was not, in fact, a priest, but was a lawyer and didn't know how to perform an exorcism. "What do you want me to do?" I snapped a bit. "Evict it." There are moments in time when you should keep your mouth shut. This is one of them, because the immediate response was, "Can you? That'd be great." Well, crap. So long story short, I ended up driving out there with a mock-up notice to quit, addressed to any spirits in possession of the property located at 1313 Mockingbird Lane without any authority under color of law, advising them that their possession was unlawful in nature and ordering them to quit and surrender the premises, or any portion thereof, within 10 days of the date of service. I also included a demand for rent of $0 and an advisement that failure to comply would result in, quote, legal remedies. I served it by taping it to the front door and then reading it aloud while my client sat on the floor, listening intently. The next day, I got a call from my client. The ghost had left. We won the competency hearing, and I got a referral for a wrongful termination case from the officer. Story 3. Represented a woman charged with multiple very serious felonies. She insisted that in the months before the offense, she'd been seriously dating one of the detectives, who ultimately wound up investigating and testifying in her case. For a variety of reasons, I trusted this client and believed her, even though the detective never disclosed the relationship in his report. So during his testimony, I asked, "Detective Jordan, you had a romantic relationship with Ms. Davis, correct?" He goes, "What?" "No," and is visibly offended. The judge ukes at me like I've lost my mind. The Commonwealth attorney audibly says, "What?" I'm freaking out because a large part of my cross and argument was focused on the bias formed by the prior relationship. And now I've got nothing. And I've lost all credibility. I try again. "Detective Jordan, have you had a sexual relationship with Ms. Davis?" As the Commonwealth rises to object and the judge starts to scold me, the detective goes, "Oh, yay. We've had sex, it just wasn't very romantic." Edit/update. State is Virginia. The jury acquitted my client of the relatively minor charge that the detective in my story was involved with, but convicted of the other, much more serious charges the detective had nothing to do with. There was a confession and video on the serious charges, so it was kind of a no-brainer. Sorry, I'm being kind of intentionally vague. There are no confidentiality concerns, since this all happened in open court, but it's distasteful to give out too much information about a client. The detective was not disqualified, his testimony was not thrown out. Impeachment, no matter how good, doesn't result in you getting to throw out a witness's testimony entirely. By the way, it wasn't really the sex that was the issue, it was that he didn't disclose it to anyone, and his repeated insistence under questioning that he didn't disclose it because it was irrelevant. Like Watergate, It's not the crime, it's the cover-up that gets you. But I don't get to demand the judge throw out the testimony or that charge just because the cop failed to disclose a prior relationship with the defendant. I just get to point it out, argue it in closing, and then hope the jury also sees the relevance. Story 4. Medical malpractice defense lawyer here, representing hospitals/doctors. This was not my oh crap moment, but plaintiff's oh crap moment. For context, usually at trial, both plaintiff and defendant will have an expert physician testify as to their opinion to whether the doctor/hospital performed everything correctly. I thoroughly researched plaintiff's expert, who was an obstetrician/gynecologist, baby delivery, and found out he had been suspended a number of times for his own botched deliveries and giving incorrect medical testimony to help plaintiff's cases. During the actual day of trial, turns out he was not licensed to practice medicine independently, without supervision from another physician, and he was 1 year into his 3-year suspension. Plaintiff's lawyers had no idea about their own expert's background, and they just sat there with a blank look on their face. Needless to say, during cross-examination, we destroyed his credibility and won at trial. Story 5. Not a lawyer, but I served as an expert witness for a case. A company had hired a web development firm to build them a new website and accused them of not giving what they paid for. The software company claimed that the requirements were constantly growing and changing. The client just played dumb and said it was the software people's jobs to figure this out at the quote, and they couldn't possibly know all these requirements ahead of time. While go through thousands of pages of emails and Skype conversations, I find 3 fun things. 1. A quote from a previous software company, with the full requirements, at 4 times the cost. 2. A conversation explaining exactly which requirements to hide from the new software company based on their cost in the first estimate. 3. An email stating they will still be able to force the software company to build the whole thing because we have better lawyers. It was a win-win. The client got a slam-dunk case, and I got paid the full fee without having to write a huge report or testify. Smiley face. Story 6. I had a client who had a pretty severe slip and fall in a pharmacy. In my state, we are not allowed to see surveillance of the subject until after the deposition or other similar testimony is taken. The rule is in place to protect defendants, so we don't coach the client based on what we see in the video. Anyway, we take the deposition, then they send the video. Not 30 minutes later, I get a call from opposing counsel wanting to settle. The video revealed that my client had fallen, passed out, and peed herself. She was very elderly and very hurt. The manager of the store had an employee put signs out showing wet floor and mop up around the lady, all while she was unconscious, all before calling 911. Settled that one for the policy limits right there. Story 7. Please don't ask for specifics. Had a case where a guy shot and killed a security guard that slapped him across the face for selling substances near a store. I knew the guy had done it. It was close to midnight, the crime scene had poor lighting, and the shooter wore a hoodie. Only eyewitness that showed up for the trial had told the police at the time of the crime that the suspect was black. The defendant wasn't Caucasian, but wasn't black either. That, in my opinion, was the argument that won the jury over. Defendant found not guilty. He thanks me while in tears. His mother and grandmother bring me cake and a thank you note afterwards. Less than a year later, I'm watching the news and they're reporting a crime where a crew held up 3 families hostage while robbing their apartments. They beat up the janitor very bad. They tied the families up and locked them in one of the apartment's bathroom, while threatening to throw a grenade inside if any of them decided to wisen up. For a brief second, one of the robbers looks right into an elevator camera before spray painting it. Close up on the guy's face. I think you can imagine whose face I was looking at. Edit. To everyone asking, he was identified but never caught. Managed to stay on the run for maybe a year and a half, and was later killed over some substance-related debt. Story 8. I had client whose $60,000 car was ruined by a shop that put in the wrong oil. We couldn't prove it at first. The engine blew up, oil leaked out, and evidence was lost. I subpoenaed their bank records, figured out they bought their oil from Costco, called Costco, and got their prices for the last 2 years. I then worked out the amounts they were spending, did some backhand math, and showed based on the values it was impossible they had ever bought the right oil. They settled in full immediately. Story 9. I was suing a landlord who failed to make serious repairs in order to force the tenant out. The hard part is proving bad intent instead of mere idiocy, so you get higher damages. Code enforcement was involved, so I request those records. The landlord left a voicemail to the enforcement department saying to hold off on the fines. They will make the repairs as soon as the tenant is forced out. That was an easy case. Story 10. This is so petty. I've had much bigger moments, but because of the character of the other side, this will always be my favorite. Doing a boundary dispute, a squabble over what was essentially a few inches of land. Opposing side was a lawyer and an absolute jerk. He was acting for himself. The whole "a lawyer who acts for himself has a fool for a client" thing was bang on for him. But he was a deeply unpleasant guy, a bully who thought that he was the smartest guy in the room. Part of his case hinged on wheelie bins, and how, prior to the boundary having been moved, there wasn't space to store a full-size bin beside the house. The fact you now could meant clearly the boundary must have moved. That was the extent of his evidence. It really was thin stuff. During the actual trial, he pulled a fast one by suddenly producing an old aerial photo ostensibly to show the boundary at the front of the property had also moved. A fast one because you have to disclose stuff like that in advance. You can't just sit on something relevant and then suddenly whip it out at trial with a flourish. Whilst he was making his submissions that it should be admissible, I looked more closely at it, away from the bit of the boundary he said it was relevant to, and realized that it very clearly showed a wheelie bin in exactly the spot his case said there couldn't be one. Told the judge we were happy for the photo be admitted after all, got the other side to confirm the date it was taken, then pointed out he'd just completely ruined his case. That photo did him for nearly $50,000 in adverse costs. Couldn't happen to a more deserving chap. Story 11. A woman was charged with possession of a large amount of cocaine. Her boyfriend was a known, big-time substance dealer with a long list of priors. Her story was that 4 officers, A, B, C, D, came up to her outside her home and demanded to know where boyfriend was. They wanted all sorts of information about boyfriend and his associates. When she refused to tell them anything, she says Officer A threatened her, including pulling out his gun and pointing it at her. She also indicated that Officer A was wearing street clothes, while B, C, and D were in uniform. Officers claim she gave them permission to search her home, where they found the cocaine. She says she never gave them any such permission and they planted/pretended to find the substances. Officer A, it turns out, had been in the newspaper shortly before the case went to trial for various serious incidents of abuse and corruption. The prosecution naturally assumes this woman is lying and simply trying to take advantage of the media publicity. At trial, B, C, and D testify that they were there with Officer E, not A. Once the defense theory developed a bit, the prosecutor offered into evidence a handwritten schedule logbook thing that listed which officers were working on each day, to show that Officer A wasn't even scheduled to work that day. There were various reasons this log might not have been admissible, and it was never disclosed to the defense until right before they attempted to admit it. But I quickly looked it over and, somewhat to the surprise of the judge, did not object to its admission, did not make any reference to the log until closing argument, then showed it to the jury and told them to look at it more closely. Officer A was not listed as working on the date, but the log also shows duty assignments for the officers working. Officer B is listed as being assigned to the evidence room or some such at the station, and Officer E is listed as being assigned to a patrol car across town with unrelated Officer F. Along with various other inconsistencies in the officers' stories, this led to a very speedy acquittal. Story 12. I represented an insurance company to recover monies it paid under a homeowner's policy, Google subrogation. It was a multi-million-dollar home with a 450-gallon custom fish tank on the second floor. The owner hired a company to clean the tank, and they brought in a fish specialist to make sure the fish were properly maintained/stored for the cleaning. The specialist then goes to lunch and turns it over to a 22-year-old they had hired a week before, who could have doubled for Keanu Reeves in Bill and Ted's Excellent Adventure. The kid just had to drain the tank and start cleaning. Up until I deposed the kid, the fish tank company claimed they had properly drained the water into the municipal sewer system. Not the case. The kid, who has been fired long before I deposed him and didn't care at all about rolling on his employer, testifies that he sparked a joint right after his boss left, and then proceeded to drain the tank, but this was the first time he had done a second-story job. The hose they had wouldn't make it to where it needed to go, so he went into the nearest bathroom. Mindful of his customer, he didn't want to dump 450 gallons of dirty fish water into the tub or sink, so he leans the hose over the counter and into the toilet. Ends up walking out and leaving it there to grab some munchies. When he got back, there was 449 gallons of dirty fish water all throughout the house. The case settled within 3 days of the deposition. Story 13. Not a lawyer, just one of the folks gathering documents. The company got an unexpected demand letter claiming we provided a defective piece of equipment and wanting big bucks for the cost of repair and all the downtime it caused. Our in-house lawyer immediately thought something was up. Letters like that are never out of the blue. They're always preceded by phone calls and emails. And he always got looped in on those, so when he called me up to have the document preservation chat, he also wanted me to pull and print all emails as soon as possible. There weren't many, maybe 30, mentioning the company. 22 were from the company. And all of them, save 3, were from when they bought the machine over a year before. The last email was the only one I actually printed, and I decided to deliver it myself with one line highlighted. Less than machine greater than was surprisingly intact for being hit by a motorcycle going that fast. I had never seen our company lawyer smile, nor laugh, but he was doing both as soon as he read it. Story 14. Family law case. I am just a paralegal, but I accompany the lawyers to court, or did anyway. Woman, our client who is divorced. Father not paying child support. He is always claiming poor mouth, saying he has no money, etc. Always getting extension to his money owed. He had a business but said it was doing terribly, and he was owing money left and right, etc. Judges had been sympathetic in the past. However, guy comes in. He owed $36,000 now, for 5 or 6 years back child support, claiming poor mouth once again. Swears to the court he has no money, business isn't going well, shows bank statements. Attorney whips out Facebook post copy I found. My brightest moment. Guy's young hot fiancée, with her new $20,000 ring, 5.5 carats, and her post saying, "Look what my sugar daddy bought me, and he paid cash. Eat your heart out, ladies." The guy looked like his life had ended. We got our full amount plus interest, and I got a $1,000 bonus. Turns out he was taking business money and never depositing it, so it wouldn't show on the books. SO company looked like it was doing terrible, when in fact was doing great. In a later investigation, his business partner sued him and won, and the business went under. For those asking, it was a bar room. And also, I hate family law. It's usually that the scumbag wins, or gets away with crap for so long, male or female. Story 15. I'm an appellate criminal defense attorney, which means I take the case after the defendant has been convicted/sentenced, and I try to convince a court of appeals that he deserves to be released from prison/get a new trial/get a new sentence. I had one case a few weeks ago that was a total travesty of justice. Black client tried by an all-white jury, not even a single minority in the entire veneer, defended incompetently by a lousy trial attorney who did absolutely nothing for him, who then got convicted on all counts and received an extremely high sentence for a relatively piddling fraud, higher than Manafort got. I raised 5 different issues on appeal, which is a lot. Typically I keep it to 1 issue, or maybe 2. At oral argument, the judges on the panel seemed pretty sympathetic during my presentation, though they asked me some tough questions. After I sat down, the government lawyer went up to speak. Before she got a word out, the first thing the judge said was, "This is like a law school exam. There are so many issues here." Had a pretty good feeling I'd win after that one. And indeed they ended up reversing all of his convictions, and my client is now a free man. Story 16. Client was private shuttle bus company, which was contracted by the publicly funded regional transit company to pick up elderly and disabled customers, done on a reservation system. Client was sued by a woman alleging that the client didn't pick her up when she called, which was true. She would never make a reservation, instead treated the service like a taxi. And as a result, she had to hitchhike into town and stay in a shelter overnight. She claimed that at the shelter someone bit a chunk of her arm off and sued the client for $25,000, small claims maximum. I brought an application to dismiss before this went to trial, on the basis that the woman's claim was bound to fail. Google the doctrine of remoteness, among other things. At the application, the woman wore short sleeves. Her arms appeared unbitten. Signal 1, this was going my client's way. She argued that claim wasn't really about the money or the chunk missing from her arm, but instead she wanted the judge to order that my client pick her up whenever she call. Signal 2, admitting your claim is bogus to the judge is not a good strategy. I obviously objected and argued that this was not the case she brought, and the judge must dismiss. The judge said to the woman, "I'm inclined to agree with Mr. David. What would you say in response to his submission?" The woman then lost it on the judge and yelled, "Screw you, you're just going to let them get away with it." She was removed from the courtroom, and the judge dismissed her claim. Story 17. Worked as paralegal/investigator. Working a trade secrets case involving the manufacture of dental wheels used to grind teeth. Long story, but go with it. Company A was a small family-owned manufacturer, but made the best product on the market from a small factory in the middle of nowhere. Sold massive amounts of product because of quality. Its location was remote enough, and the owner paid employees so well, the employees stayed there forever. All of them had worked there for 30-plus years. When the founder of Company A died, it was sold to International Company B, because the kids and grandkids had no interest in the company. Company B then closed the old factory and tried to use Company A's formula at their facilities. Company B couldn't make the formula work. Now enter Company C, another international company who lost the bid on buying Company A. When Company C heard about the problems Company B was having, they bought the old factory facilities and then rehired the old staff to restart production. All the employees of old Company A were delighted to have their good-paying jobs back and went straight to work, producing the better quality items once again, and Company C's product worked. Company B sues Company C for trade secrets violation. When you buy a company, you buy their trade secrets. And this company had a bunch. This product was just one part, but the most profitable part of their operation. Thus, Company C, because of their action, was accused of violating the laws governing trade secrets. Company B even managed to get a temporary restraining order against Company C in federal court, and Company C had to stop manufacturing at the old plant now owned. This is when I enter the picture. Our firm represented Company C, and I was assigned to interview all the employees. I was in the living room of this delightful older lady in her late 50s that offered me snacks, asked me if I was married and wanted to set me up with her granddaughter, you name it. Best and funniest interview ever. Then she drops the bomb. I asked her how she knew how to make the product. All my previous interviews said so-and-so taught them. She said, from the directions on the wall. Total moment of silence. Directions on the wall? Yes, she said. No one ever looks at him, but there is a board on the wall with the directions. I called the janitor of the facility from her phone. Yeah, this is before cell phones, and had him meet me there. He unlocks the place, and yep, covered in probably 40 years of dust, making it just part of the background, is a board with the entire process on it. Thus, when Company B sold the factory, which was eventually purchased by Company C, Company B accidentally sold the trade secret to Company C because they abandoned it on the wall. I did serious evidence sourcing on this. My best pictures were of this 65-plus-year-old former janitor knocking the dust off the pages, taking the entire board off the wall, putting it in paper bag, and sealing it so I never touched it. Every picture he smiled for the camera. His screw you expression was priceless in every picture. They were so freaking funny. The judge in federal court was laughing his head off when he heard the details of what I found to reverse the restraining order. When he opened the bag, he laughed even more. The factory reopened immediately. Company B and C settled by agreeing that they both got to use the trade secret but couldn't sell it to anyone else. What they really figured out was, those little old ladies had slightly changed the formula over the years and slightly made them better over time. Even the formula on the wall didn't work as well as these little ladies did. Story 18. I was a second-year associate and handling my first trial. I represented the plaintiff. The defendant had an expert witness who had testified previously in about 40 similar cases. This expert came out to my client's property and did a completely phony examination of the issue, and his expert report was equally as phony. For those of you that don't know, expert testimony needs to meet a certain standard, the Dober standard, at least in my state, in order to be admissible. This guy basically took some photos and put a ruler on the ground a few times to make his report seem legit. The partners at my firm told me it wasn't worth trying to file a Dober motion to strike his report/testimony because the case was low value, under $100,000. And those types of motions can be very complex, and didn't want to bill the client for it. I was so angry about this guy being deemed an expert that I came in on a weekend, on my own time, and drafted a 20-page motion to strike his testimony. I didn't bill the client a dime. The defendant didn't file a response to my Dober motion to strike. Instead, they waited until right before the expert was set to testify. He had been sitting in court racking up fees for 2 full days beforehand. The judge had the jury leave the room, put the expert on the stand, and allowed the defendant to do a direct examination of their expert. The defendant's attorney, not taking my motion seriously, had their inexperienced associate, just like me, do the examination. It was incredibly basic and didn't respond to any of the points in my motion. I was in charge of doing his cross-exam. It was my first cross-exam of a witness, ever. I tore the guy, a seasoned expert witness, apart on the stand. I got his entire testimony and report struck. They also had a second expert witness, who was pretty terrible but not quite as terrible. I also did his cross-exam. Realizing that they were in serious trouble without their primary expert, and their second expert at risk of getting struck, the lead counsel for the defendant, a named partner at a well-known firm, did the direct exam for the second expert. I again did the cross. I got the second expert's testimony struck, except for one very, very tiny area, so essentially he was forced to testify with both hands tied behind his back. It was the most gratifying moment of my legal career so far. Story 19. I was at a hearing arguing that my client was wrongfully terminated because the employer failed to abide by the proper procedures. During the hearing, a witness for the employer tried to offer documents that were fraudulently altered in order to make it look like the proper procedure was followed. I noticed the alteration. Opposing counsel quickly got that witness out of the room, and after a quick adjournment, my client got a large settlement. It was an age discrimination case. It wasn't a very strong case, but one of our arguments was that my client's supervisor railroaded him by terminating him without following the proper procedures. This employer, a government entity, is supposed to give its employees certain number of days of advanced notice before a termination. During discovery, the employer disclosed documents that indicated that they didn't give the client proper advance notice. During the hearing, the witness shows up with the same paperwork, but with completely different dates, indicating that they did give him the proper notice. The alteration was obvious to me, because I was going to examine that witness as to the date. So once I looked at the document she was giving me, it was obvious that something was wrong. Their lawyer had earlier given me an entirely different set of documents. I should mention that this was a hearing before a Civil Service Commission and not an Article 2 court, so discovery was a little less rigid. Anyways, their forgery turned a weak case into a strong case. Story 20. My favorite was a proceeding that actually led to disbarment of the opposing attorney. Opposing Addy was sent discovery requests that he never responded to. Multiple emails were sent and nothing. Moves to compel, and the Addy shows up furious that we file a motion and are wasting the court's time. Says we're playing games, and claims that he sent multiple emails with the documents. Judge asks him to produce the emails. He can't. Judge orders him to produce the discovery and awards us fees and costs for the motion. 3 months later, we get a CD with the discovery. It's all PDFs. I take a look at the metadata and see that the documents were created the day before. I call the information technology guy at the opposing party and ask if they keep the original versions of the documents. They do. I get them and compare them to the discovery. They're different. We file a motion for sanctions. Opposing counsel is furious that we're playing games and wasting the court's time. Says he will counter-sue for harassment. At the hearing, we present the evidence. The judge asks opposing counsel to explain. He can't. Judge orders a forensic examination of his computer. Forensic examination shows that he altered the documents and backdated them. He also deleted a bunch of emails. Judge refers the matter to the state bar. Opposing counsel is disbarred. It was a long process, but it was worth it. The case settled shortly after. Story 21. I was reviewing the transcript of an interview with a child. The child made incriminating statements against my client. At one point, when discussing the allegations, the child used an odd word, but I didn't think much of it. A few days later, I was watching a video of the child interacting with their grandmother, who hates my client, from about a week before that interview. The grandmother used the exact same odd word in the exact context the child later used it. At that moment, it became clear that child had been coached. It was the first real aha moment of my career. Story 22. I worked on a case involving defective processors. In discovery, we got emails from the defendant's engineers that had worked on the processors. They were in an Asian country, but the emails were in English because they were going to U.S. executives. One of the more senior engineers basically laid out the exact defect we were suing over, explaining what the problem was and why it was their fault, and finishing with, "This is big problem, we ship crap to customer." Needless to say, we hit them over the head with that in mediation, and they settled shortly after. Story 23. I knew the cops beat up my client and framed him. They described a knife in his possession that caused them to fear for their safety. Oddly, they never seized it. We won the criminal case and filed a civil rights case. While deposing one, he described the knife in detail. No more than 3 minutes later, he slipped up and claimed his partner told him my guy had a knife, but he never saw it himself. I told him, "That's not what you just said," and saw him panic. His lawyer panicked too and asked to see me outside. When we got in the hallway, I withdrew my settlement demand, and the case settled for a substantially larger amount within 45 minutes. Story 24. I represented an elderly Indian couple who didn't speak English very well and owned a rental property. They had a tenant at the time who had not paid rent in over 6 months. They had tried to evict her on their own, but when they got to court, the tenant produced some handwritten notes, which they had given her the year prior, thanking her for payment. But they failed to date the notes. Of course, the tenant added recent dates herself. The tenant also produced a partial certified check receipt, but most of it was illegible. Anyway, because of their poor English, they had difficulty understand the questions and giving intelligent answers, so they lost the initial case. They hired me to help address all of the various lies that the tenant was putting forth. Anyway, we refiled. I had my clients pull the banking records so we could show the date that the certified check was actually deposited into their account. The plan was simple: let the tenant make the same arguments and then present the banking statements showing the deposit date. My clients also found a photocopy of one of their notes, but it was undated, unlike the copy the tenant presented the last time. Well, when the judge finally understood that the things the tenant had presented occurred the year before, his cheeks turned bright red, and he asked the tenant, "What year did you make this payment?" The tenant started saying something like she couldn't be exactly sure when, and the judge cut her off again in a very loud voice. "What year?" Needless to say, the clients got their eviction granted. Bonus content: when the tenant arrived at court, I watched as she got out of her car, walked to the back and pulled out a wheelchair, and proceeded to stay in that wheelchair until the case was over. Once the judge left the courtroom, she folded up the wheelchair and carried it to her car, mumbling that she hates freaking lawyers. Anyway, that was a very satisfying day. Story 25. I was testifying for the defense. A young man had been arrested for assaulting a police officer, allegedly throwing bottles during some unrest in Oakland, following the verdict in the trial for the trial of the cop who shot Oscar Grant in the back on the Bay Area Rapid Transit platform. I had been there filming stuff, caught his arrest on video, and his brother found my footage on YouTube and asked me to testify. I had only seen bottles being thrown from this one corner of a parking lot, from behind me, with the bottles flying over my shoulder. The defendant was in a group in front of me. On the stand, the prosecutor seemed to think I knew the defendant and was there basically committing perjury on his behalf. I explained why I had been there that night, that I had never seen this guy before, hadn't been coached by the defense, and hadn't been paid other than a small amount for my travel and time. Finally, exasperated after much back and forth, the prosecutor says, "Well, if you don't know the defendant, then why are you here testifying for him?" I thought for a moment and said, "I guess I just wouldn't want an innocent man to get convicted for a crime he didn't commit." He got visibly flustered and quickly moved on, trying to insinuate that if I didn't know him, how would I have known to be looking in his direction to see whether he was throwing things, and I tried explaining that if you're looking at a group of random people, and one of them throws something, you will naturally fixate your attention on that person. But because nobody in that group threw anything, there was nothing to notice in the first place. It looked like the police just grabbed him at random. They rested, the defense attorney bought me lunch down the street, and then he got a call from his colleague that the jury took all of 10 minutes to return a not guilty. This video does not promote illegal activity. Stories are shared for commentary and education.